try to share my own experiences, which I have derived being a lawyer, practicing lawyer, and managing different arbitration cases, including some high-stake arbitration matters. We have to understand first the backlog problem which is prevailing in Indian judiciary, the system. As per a survey being published by Government of India itself in 2018, it is estimated, it was reported that more than 3 crore cases were pending at that point of time. I am taking a threshold of 2018. And many cases out of these backlog are basically the cases which are almost 10 years old. 64,000 approx cases were pending in Supreme Court and around 50 lakh 83,000 in high courts and almost 29,305 something in a figure in lower court. We have to understand, I hope I am audible to you all. I hope I am audible to you all. Yes, sorry, this technical glitches because it needs to be confirmed that I am audible, because otherwise it would be a monologue, All right. So the causes, we have to understand the causes of pendency as well. There is a capacity constraint. Unfortunately, the infrastructure in our judicial system has not been developed at par with the growing population, growing economics, as well as growing litigations. We have seen that there are, if you take a per capita system, we have approx 12 or 13 judges per billion population, and we as a nation stand at the bottom of the list in terms of speedy and quality administration of justice. There is a scarcity of judicial appointments. There is a huge lack of judicial infrastructure. There is a absence of time frame, despite of many legislations candidly and very categorically mentioning about this timeline, the outer timeline to dispose of the cases. We have seen that in a later interpretation by constitutional courts, particularly High Court as well as Supreme Court, the time has the time limit being given in the court or act itself has been said to be directory, not mandatory. So recent example, you can take it from Insolvency and Bankruptcy Court. Insolvency and Bankruptcy Court 2016 mandates that the adjudicating authority, in that case that is National Company Law Tribunal, is mandated to decide a Section 7 application within 14 days of filing. So when the matter went to the Supreme Court, the Honorable Supreme Court in one of its judgments said that it's a directory, it's not mandatory. So, and what happens with impact of pendency? High cost of legal fee, loss of memory by witness. That is also very, very important. We have to understand that. In a criminal trial as well, we have seen, particularly in a civil trial, because we are talking about arbitration, so let's confine to civil trial. We have seen that when it comes to lead the defense evidence in the court, at that point of time the list of witness which was being filed, or under the strength of whose the written statement was being prepared by defense, some witnesses are not present due to change of their job or their death or their old age. So it affects the quality administration of justice. We have also seen that arbitration can be, and to a certain extent, barring certain exceptions which I will try to cover, a successful tool of dealing with the pendency. How it happens? You all are aware that if you have an arbitration clause in the agreement, in the contractual framework, and if there is any emergence of dispute between the parties to that contract, the matter could be referred to the arbitration. And now, after this, arbitration law still isn't developing mode, and it is now yet settled that when you have an arbitration clause, each and every matter pertaining to the dispute touching or arising out of that arbitration clause has to be dealt in arbitration proceeding itself, barring certain exclusion which is provided in the Arbitration Act itself. Now, we have to understand that I will try to leave these aspects of lok adalat, mediation, negotiation, conciliation. This may be taken in a question and answer session, and I will try to focus my arguments, my submission, my lecture on the arbitration component itself, because that is of a primary importance for you all law students and law professionals. Now, we have to understand the concept of arbitration proceedings, how it helps in reducing the backlog, how it helps in gaining the confidence of the parties to a dispute resolution mechanism. Why I say confidence? Because confidence is very, very important. Because now India is developing, India is one of the growing economies. It's one of the fastest growing developing economy. And we are witnessing huge influx of foreign direct investment, FDI, FIIs. So whenever a foreign investor or a foreign company is venturing into India or is inclined to do certain business in India, they are being advised by their local councils back at their respective end that Indian judicial system is ultra slow. So in case of any dispute, be ready to and embrace yourself for a long legal fight. So that's why you would see, and we have been seeing that even if we advise to, in a particular case, that we don't recommend arbitration, even though we are being persuaded by the client to retain the arbitration clause for the speedy dispensation of justice. Now, how it happens? Just to give you a very short background of the arbitration proceeding, of course you must be aware of, but just to refresh my memory to that effect. Arbitrator once appointed. Now you have to understand that the appointment of arbitrator has also been dealt in a different occasion by Supreme Court in a different level, and with regards to ensure the impartiality of the arbitrator who is going to adjudicate your disputes, being referred to him under the reference of the arbitration clause. However, once the matter is referred to arbitration, you know the process: filing of a statement of claim, then a statement of defense, counterclaim, rejoinder, evidence, everything. And then the final, the good part is that arbitrator is not bound to follow the procedures of CPC. Now there are two contradictory judgments of Supreme Court, and now the matter has been referred to a larger bench which is yet to pronounce its judgment, because in one of the judgments Supreme Court has said that the provisions of CPC are binding on the arbitration proceeding itself, while in one of the same coordinate bench judgment of Supreme Court, it says that it could be only a guiding principles. So that's when this question came, when the Supreme Court was confronted with particular this situation, the matter has been now referred to a larger bench which is pending adjudication. More or less, let us assuming that CPC is not mandatory, in that event, what happens is arbitrator with the consent of parties decides the module of the proceedings, that how the proceedings will proceed. Why it is important? Suppose that you are dealing with a high stake litigation, 5,000 crore litigation, some power or discount company dispute, and when the evidence affidavit is being filed, these days every day, barring certain exceptions like Shimla High Court in original jurisdiction and some other courts, I have personally seen that where the evidence is being recorded by the court itself. Otherwise, normally it is being tendered by the way of affidavit. Now, in arbitration, we can waive off the tendering process. In court, we can't. Why it matters? Sometimes the documents, exhibits with the evidence affidavit runs into thousands of pages. So if you start tendering a document, even if it's a 2-hour session per sitting of the arbitration proceeding, it will take months, if not years. So the parties can mutually decide, and the arbitrator can rule that there is no need of tendering of the evidence. Now, thereafter, after finalizing the modules of the arbitral proceedings, when the matter is finally argued and award is being published by the arbitral tribunal so constituted who entered into the reference, the limit of appeal, statutory appeal, is very, very confined, very limited. I will come to that aspect later. Now, earlier what happened that arbitral proceedings also were taking quite long period. I am a counsel in various matters where we are doing arbitration for 3 years down the line, or 4 years. Some matters are still pending for 5 years. So a negative sentiment penetrated into the business community that see what is happening. So we left the court to come to arbitration, and again the story is same. Government of India, yani Parliament, realizing the importance of the institutional arbitration and the time-bound procedure to complete the entire process, amended Arbitration Act way back in 2017, if I'm not mistaken, and it was mandated to complete the proceedings in 1 year from the date of entry into reference, meaning thereby when the arbitrator entered into the reference to adjudicate the disputes which have been referred to him for adjudication. Now, important part is, thereafter what went, that it was realized that 1 year is basically, relatively very low. Then with the new amendment, the period has been extended to 1 and 6 months for completion of pleading, and then 1 year for process. Though it is open for extension. There is a provision, if I am not mistaken, section 29 capital A of the Arbitration Act, whereby you could go to civil court for seeking an extension. Why it is important to ensure the time-bound disposal, and what separates the arbitral award from the normal degree is very important to understand. Right? First appeal is a right in the case of degree. Then you have a regular second appeal where you can only raise the question of law, and then you have a Supreme Court. So then you have an appeal or a Supreme Court matter, SLP. It takes time. In arbitration, the cases are entirely different. though of course parties have been given right to challenge any arbitral award under section 34 of the Act. However, the grounds of the challenge are very limited. So the party intending to challenge the arbitral award has to satisfy to the concerned court under section 34 that his application challenging and assailing the award precisely falls within these classifications as enshrined in section 34. Further, Supreme Court in multiple judgments and repeatedly held, and various high courts as well, that in section 34 the court cannot assume the role of the court of appeal. It's not a statutory appeal. Now, though the idea and the depth of the subject is too much to be discussed and deliberated during this short time, but it is worth reading some of the recent judgments of Supreme Court, wherein repeatedly it has been held again and again, time and again, that even if the inferences being drawn by the arbitrator, the reasoning could not be challenged. There could be two possible reasoning of one particular issue, but only for the reason that arbitrator has taken one aspect and has left other is something which could not be challenged. So it is very, very confined, it is very, very limited. How arbitration mechanism in a broader context could help businesses, could help parties for amicable solution is also very important. Nowadays you would have seen that every state government is puts a place on advertisement in in public domain, that please come and get the matter settled by the way of mediation. So there is a lok adalat concept as well. My point is that if arbitration clause is properly inculcated in the agreement, and if the parties are serious in settling their disputes which have emerged during the course of their business transaction, the arbitration is a perfect tool and module for the time-bound disposal of the matter. In any way, we have to understand there are always merits and demerits of every process. So that's why it is important that arbitration clause is very, very important. Normally what we usually make a mistake by copy and sometimes that we do wonders with copy and paste tool. So we must avoid doing wonders with copy and paste tool. You being the law students should be very, very serious if you want to practice in if you want to be an arbitration lawyer. So that does not mean that you will automatically become an arbitration lawyer, or from day one you would start getting the arbitration work. My advice to you, and this I keep on telling to all law students wherever I interact, please focus your practice for certain initial years to a lower trial court so that you could understand the nuances of trial proceedings. At the end of the day, in arbitration is also a trial, civil trial, though it's a quasi-judicial proceedings. But it's like a trial because you are conducting trial in the arbitration proceedings itself. So arbitration, if properly handled and managed, will ensure that there is a timely disposal, meaning thereby disputes which have emerged would be settled very fast. Meaning thereby that the parties to the business, particularly foreign direct investors, foreign institutional investors who are coming to my country, to our country to invest, to venture into the business, they would have this confidence that yes, now in India, if there is any dispute in the transaction, because dispute is an indispensable part of the business transaction. howsoever cordial environment you may have, dispute emerges, in in a business transaction. So the sentiments are very important. So if that's why you would have heard that there is a demand in India for institutional arbitration, development of institutional arbitration. Like we have some institutional arbitration, more particularly Delhi International Arbitration Center (DIAC), and DIAC is doing some wonderful work, some wonderful job, and it is, but still a lot needs to be done. Now, if you take per contra example of Singapore International Arbitration Center (SIAC), or you go with ICC Paris, or you go to London or other countries, even Dubai Free Zone, there is a Dubai International Financial Center. This is separate from main Dubai legally, and you have English laws to govern your business transaction there. So Singapore International Arbitration is something from which we must draw and derive certain inspiration. I have been there, I have seen how they work, how effective they are, and how countries across the globe, even for the inter-countries agreement, are preferring Singapore International Arbitration Center to be their seat of arbitration in case of any disputes. Arbitration can also do wonders though as a lawyer I should not say, you may take it in a lighter vein, that we, the lawyers, and you being budding lawyers someday down the line, God willing, you would, of course, the bread and butter of a lawyer is his or her fee. So professionally speaking, so we have to speak sometime on a professional standard, sometime on an ethical standard, and sometime on the requirement standard. Cost-wise, arbitration proceeding is much cheaper than the court proceeding. In earlier arbitration regime, it was not, because at that time Schedule 4 was not there. Fee was very astronomical. Some arbitrators were charging 15 lakh per sitting. Let aside lawyers fee and 5-star and these and all. You would have seen and you would read a lot of articles about that in law journals and on social media or internet platform. Now, Arbitration Act has specified the fee as well. So the fee has been capped. If I am not mistaken, that is Schedule 4 of the Arbitration Act, wherein it is being defined that what would be the arbitrator fee, number one. Number two, the immediate requirement of paying the court fee in like in a civil case, it stands suspended, and then when you get an award, you only at the time of the award, you have to pay, depending on the stamp duty requirements. Like in Delhi, you are required to pay 1% of the award amount by both parties in event of the consent award. And if it is a contentious award, then the cost of that stamp duty, like court fee, is also included in the award itself. Sometime and sometime may not be. So cost-wise, it is very effective. Time-wise, it is very, very effective with the new regime. And we are now seeing, post 2017, though as a practicing lawyer of arbitration, I could say that we were required to seek extension from the mandatory, in addition to the mandatory time period as is stipulated in the Act itself. But in majority of cases, we have seen that within the given time frame, the arbitrator was successful in completion of proceedings. So that's very, very important. Am I audible? Please confirm it. Alright, and please also let me know what is the time till I have to speak, and then we will open the floor for questions. Alright? Now, what time you would ask, you would prefer me to stop and to open the floor for questions? Yes, please go on. So you want me to keep delivering the lecture till 5 o'clock? Yeah, I have no problem. Just to understand the time constraint as well. So I will try to reduce the time for lecture till 4:40-45, so that in question answer session I could devote more quality time for answering the queries, and in whilst answering the queries I would be able to clarify more details from the subjective perspective. So moving forward, thank you. So moving forward, we have to also understand that the process of arbitration, though it may not be directly related to the subject as of now, but let me take this opportunity to impart you this basic, that how the arbitration proceedings from the practical perspective are being initiated and managed. What we read in law books, statute books, and what we practice in court is an entire different scenario, perspective. I would like to clarify what I mean by saying this. Arbitration, suppose that, taking an illustration, Mr. A and Mr. B had an arbitration clause for any contractual matter, let's say for supply of certain things, of a purchase of anything, and Mr. B had to pay Mr. A some money which Mr. A had not been paying despite multiple reminders and requests. So of course the aggrieved party will have to invoke the arbitration clause. So that's very important, invoking. Now, if you don't invoke the arbitration clause, unless you invoke the arbitration clause, especially, you can't seek remedy under the arbitration proceedings. Invocation is must. Various judgments by apex court clarifies this fact that arbitration clause is independent of the agreement where it is being written. So arbitration clause has a survival effect. Otherwise, if the arbitration clause not have the survival effect, with the agreement it will go. So and for other specific reason as well, the arbitration clause itself is independent of the agreement itself, main agreement itself. Now, invocation means that if I am aggrieved by your action, and if anybody of you is a party against me, and I want you to be referred to the arbitration, the disputes which have emerged between us, then in that event, I have to first invoke the arbitration clause qua you. I will say in my notice that these are the disputes which you have failed to address, redress, and by this legal notice, I am invoking the arbitration clause, and as per mandate of section 11 of the Act, 30 days period is important, is a mandatory rather, not important, cooling off period or a statutory time frame, that if I have invoked the arbitration clause, if I want to go to High Court for the appointment of arbitrator, in that event, 30 days I have to wait. If the both parties to the disputes are not mutually agreeable to an arbitrator mutually, if both parties agree, they decide that yes, we are willing to appoint Mr. X as an arbitrator, and Mr. Arbitrator, subject to the disclosure being given under section 12 of the Act, enters into reference, then he can proceed. And if any of the party, if there is no mutual consensus, then of course you can go to High Court. You have to remember one thing, that appointment of the arbitrator under section 11(6) of the Act is vested only with Honorable High Court of that jurisdiction. I will come with the jurisdiction aspect as well. I am trying to cover this arbitration in a very short discussion, in a nutshell rather. Now the Chief Justice of the High Court is empowered by the Act itself to appoint the arbitrator under 11 subclause 6 of the Arbitration Act. Normally Chief Justices designate this power to their brother judges and sister judges in the court, and they take up the arbitration roster. So the arbitration, you go to the court. Now the court, as per the settled judicial proposition, while deciding an application under 11.6, has only three things to see. Proper arbitration clause, that yes, there is an arbitration clause. Number two, that place of arbitration. Place of arbitration means that whether the High Court, which has been approached, has a territorial jurisdiction to entertain, meaning thereby that if my and your agreement says that the place of arbitration, now place and seat and venue are again the complicated term. I will not venture into this because it will take much time. The place of arbitration shall be New Delhi, so of course the Delhi High Court will have jurisdiction. If I say that place of jurisdiction will be Saharanpur, then of course the Allahabad High Court would have the jurisdiction. So the court will see the arbitration agreement, number one, the arbitration clause, that valid arbitration clause. Number two, the court will see that whether the court itself has a territorial jurisdiction to decide this application under 11.6. Number three, the court will see that there exists certain dispute. The court does not need to travel into the merits and demerits of dispute. This is what some High Court on earlier occasions tried to do, and this was negated by Honorable Supreme Court, stating thereby that it is not the duty of the High Court exercising a power under Section 11.6 to go into the merits and details of the concerned dispute. Just the court has to see that yes, there are certain disputes. Whether that dispute is good dispute, whether that dispute lack merit, that is a patently feeble dispute, spurious dispute, that is not up to the court to decide. So the court will see the three component. Court will appoint an arbitrator, and then the arbitrator, subject to disclosure being given. Now the Section 12 has been widely revamped in the new amendments just to maintain the impartiality of the arbitral proceedings. So subject to the disclosure being given by the arbitrator under 12, the proceedings will happen, which I have just concluded in my first leg of the submissions. Very important aspect is that if you are representing any of your client in arbitration proceedings, of course, you being all law students, you would be entering into profession someday down the line, one final year or fourth year or third year, So, and certainly at certain time you will be entrusted with responsibility of representing your clients in arbitration proceedings. So you have to be very, if you want to practice in the arena of arbitration laws, you have to be very vigilant to keep close eyes on the developments. Law is a very dynamic thing, and of these commercial laws and the corporate laws, venture is of utmost dynamicism. Every day law keeps on changing, as we are seeing with insolvency bankruptcy court, as we have seen and we are seeing with arbitration laws, arbitration act keeps on evolving for a better perspective. So suppose that you have built up your strength of certain dictum of the judgment of the High Court or Supreme Court, which of course you are not aware that it has been overruled by a larger bench of that High Court or the Supreme Court, as the case may be, then you are terribly missing something. So that's why you have to, as a law student, as a lawyer, this is a profession when you have opted for it. So at the back of your mind, you must be prepared that till the last breath of your life, you would be required to read and read. There is no other substitute. So if you are not fond of reading, this profession is not for you. That's as simple as that. So you have to understand, you must go with the statutory provisions, then you must go with the latest legal developments. There are journals, there are citations, nowadays every information is available on a real-time basis on public domain, so you could have a first track information of every legal development, and thereafter, once it is once you are into practice, you can further improve and you hone your skills by analyzing the various legal developments in your own understanding, by developing a concept of your own understanding. So that's very important. I will now, because it's 4:40, I will now throw this, open this with the permission of the moderator, of course. I will request the moderator to open the floor of the house for questions so that we could cover it in wide range.